Tony DeWitt here, Missouri appellate attorney, retired. None of what follows is legal advice. I'm here to do some video for you today to talk about an interesting subject on the law, and here it is. Two things happen at the beginning of a trial that quite often determine what the outcome is. The first of those is jury selection. And in the husband in a burn pile trial that's going on in Georgia right now, the jury selection wasn't something that anybody got a chance to look in on, but apparently the prosecutor is fairly happy with the jury that they have impaneled. The next thing that happens that is often determinative of the outcome is the opening statement. Now, the opening statement is not an opening argument. You'll often hear it referred to that way by news media people who don't understand what they're covering. But the reason there's no argument in the opening statement is because the purpose of the opening statement is to give the jury a preview of the case and sort of a roadmap of the case. Now, the key to a good opening statement, first of all, is absolute mastery of all the facts in the case. You know everything that happened, you know why it happened, and you're here to tell the jury all of the things that the jury is going to need to know to give you what you want, whether it's $1 million in damages or, as in this case, a conviction. There is a danger in doing a rambling opening statement as opposed to a well-structured opening statement. And there is also a danger in using vague and ambiguous terms and basically trying to sound smarter than you actually are when you do an opening statement. Now, it probably sounds like I'm throwing rocks at the prosecutor here, and I'm not really trying to, but I don't think that he put in the time to think about the way that he ought to set this up. I want you to listen to this first little snippet here and see if you can figure out what he means by some of these references.
You have to ask yourself certain questions. You do not have to ask yourself, was Gary murdered? He was. The evidence is going to show that. You do not have to ask yourself, was Gary Ferris burned on a burn pile? He was. The question you have to ask is, who did this? Who did it? This is a murder. This is a heinous murder. He was shot, killed, put on a burn pile, and burned. The question you have to ask, what the evidence demands an answer of, is who murdered Gary? Now, these people that are here to see the trial, what I want you to do is they're going to follow the evidence too. I want you to look at me. Don't worry about that. Follow the evidence. The evidence demands an answer, and the answer is close. It's at hand. It's close to me. It's close to you. It was close to Gary.
I think the prosecutor started out okay with, there's been a murder. You don't have to ask if there was a murder. You don't have to ask if the body was burned afterwards, because we know that. But at the same time, he then starts getting into the who did this, and instead of pointing at the defendant and saying, that woman over there did this, he says, the answer is close. Well, what does that mean? It's okay to ask a jury to answer a question, but you have to clearly define the question. You can't just give them well, it's close. Well, close can mean in terms of distance. It can mean people who are close-knit. There are lots of different connotations to the word close, and you have to be very careful where you lead a jury in opening statement, because the direction that you push them in is the direction they are most likely to go in. And so I thought that portion of his opening statement was not particularly well done. But there was a section of the opening that I thought he did fairly well in. Let's take a look at that now.
But this is Tuesday, July 3rd. We don't know exactly when Gary was killed, and we don't have to prove that. The evidence does not require us to prove you the exact time that Gary was shot and killed. But we have a very good idea. Tuesday night around 10 p.m. most likely. Last time he used that CPAP was Tuesday morning. A little after midnight, he got on it. He got up that morning and turned it off. And that machine, when they did a search warrant, shows the times. He's not going to bed without that CPAP. He never used it again. We have no reading that was used again. Now, on Tuesday around lunchtime, Gary had an interesting relationship with his family. And they had some good times, but it was also different. I don't know about y'all, if I go in a restaurant and I see a friend or a family, I'm going to go up and say, hey, Tom, we're going to hang out, we're going to do stuff. Especially if it's my dad. Well, on Tuesday, Scott and the defendant were working, and they decided to go to lunch. They went to Cherokee Ranch restaurant, a local restaurant. While they were there, Gary was already there. He pays his bill and he leaves and doesn't say a word to him. And that's not uncommon. Because their relationship is not a touchy-feely type of relationship in this family. That's not this family. They communicate a lot by text messages, emails, instead of just calling and talking. That afternoon, Scott went to a lake house. He was there that afternoon and evening. There's a text asking about sleeping over for Aston, which is Chris's daughter, the grandchild. There's a text from her, from the defendant, saying, what about tomorrow night, not tonight? And that was going to show that the defendant loved her grandchildren. If they were close or she could get to them, she would get to them. But not this night. There was a visit Big Daddy and Grandma. That's what they call Gary Melody. Big Daddy, Grandma. Chris and Aston came over that night. Gary was getting the burn pile ready to go. He liked to burn things. He liked to do it. They were there talking to him, see what he's doing, and they left that night because couldn't stay, so they went back. About 10:52 p.m., there's a phone call between the defendant and Scott, and it was basically the defendant saying, the horses are out, when are you coming home? Scott's with his friends. He's down at the lake or whatnot. She's calling, when are you coming home? The horses are out. He gets home, Scott does, about 11:30. Sees the burn pile's burning. I think he says something along, I see Dad burn the burn pile, or he's burned the burn pile, or something like that. Wednesday morning, Scott gets a debit card from his mom because he can go play golf. He has this thing on 4th of July that he would play golf, he and his buddies. You're going to hear about his buddies, Philip and Ted. That's just what he did. So about 6:15, I think he goes to the door, and I think he calls or texts his mom, the defendant, says, needs the card. She comes out, gives him the card, he goes to the ATM real quickly, right down the road, gets some money, and comes back to go play golf. He's playing golf with his friends. Chris and family, they go to the Peachtree Road Race. Chris and Aston, they then go to the Cracker Barrel, I believe, that morning. Scott goes to the lake on a pool party, and he's there in the afternoon and evening. The defendant actually leaves for Lake Lanier to go be with Amanda, Chad Bruce. And you're going to see in things here. You're going to see it's kind of this way. And Chad Bruce was the fiancé, now husband to Amanda. Amanda Bruce was Amanda Ferris. And they go there and hang out, and you're going to hear about that. And at some point, they come back from the lake. Chris drops Aston off at the house on Wednesday night because they want to see and hang out. Now, these times may change. I may get them wrong, but you're going to hear the times as we go through. Wednesday night, July 4th, kids around 11 or 12. They come in, they live out of state, they come in, they want to see everybody, they want to see Big Daddy, they want to ride some of the stuff on the property, they want to do things. It's 4th of July, and the defendant wants the kids to go to bed early. July 4th, 3rd, Tuesday, 4th, Wednesday, 5th, Thursday. The defendant goes to Walmart, checks out around 9:30. Scott spoke with the defendant and Amanda about 11 o'clock that morning. Now she goes and gets some supplies and some things at Walmart. So here's 5th is where it breaks open. Scott has got a connection or connect for some golf clubs. He's going to go to the PGA and get some golf clubs. He sees Amanda up at the house, and so he's driving down his driveway from the barn to leave. And he sees Amanda, goes up and starts talking to him. And defendant is asking, "Have you seen your dad?" And Scott can be sarcastic, and he can be hard on his mom. He talks to her. They kind of go back, and he says some things, kind of sarcastically. We talk about where's dad, things like that. And they start looking for him. Now, the defendant starts asking people, "Are you on the bank accounts?" or something like that. As in, maybe he's using the funds or the accounts to try to find where he's at. But his Mercedes is at the house.
Now, it's always smart to give a jury a roadmap, and especially a timeline. You've probably seen me do that in my videos several times, to put up a timeline that I've done in either PowerPoint or Canva so that you can see the whole case in a nutshell. And when it comes to culpability for this particular murder, the culpability basically boils down to July 3rd, 4th, and 5th, and those are the dates that are on this timeline and this calendar that they're going to show and go through. And what he does here is fairly effective. He puts it out. I don't think his oratory style is particularly effective. I think he would do a lot better if he would quit walking around the courtroom and simply sit there and go through this timeline in a more workmanlike manner. But I suppose he is building toward a climax or something, and he feels the need to throw a little theatrics in there. And again, I'm not sure that's particularly effective, but this part of the opening statement is very effective. But what preceded it was not effective. I call it the House Beautiful tour of evidence of where they lived, which is probative of pretty much nothing. Let's take a look at that.
If you walk in that front door, this is what you see. Now, as you walk in, you're going to see evidence. If you walk in that front door, and I'm staring at the steps, if I'm staring at the steps and I turn right, you can go to what I call the kitchen table. If you turn left, there's a bathroom. If you go straight, you're going to go down the hallway to the master bedroom. This is the master bedroom. That door right there, you can walk out and go to the balcony. And that's where that oval porch was. You can stand out over that and look. You can look at the pond. Study room, library, very nice. Very affluent. This is the dining area, looking out towards the pond, nice. This is the kitchen. This is the doorway from the kitchen to the basement. You go down the basement. To the left here, if you look at the picture, there's that light switch and whatnot, then there's that cabinet. Right around the corner is the steps you come down. It's 12 steps down, the landing, 4 steps down. You come down that landing, you stand right there. If you're standing off the steps, you get off the steps, you look straight forward, you're going to look at that bar. This is looking back from the, kind of to the side of the American doors, looking back towards the bar. As you look at this picture, to the right is a hallway. You go down that hallway was Gary's office, where he'd hang out and do stuff, work. He liked to get up in the morning. Because he was a partner, because he'd been doing it so long, because he had those routines, he would get up and go check email.
It took the investigation more than a year to come to enough evidence to get an indictment against Melody Ferris, the woman that they assert killed Mr. Ferris, Gary Ferris, in this case. And you would think that over that period of time, you would have developed a fairly easy understanding of the key facts. So Part of the opening statement was designed to show that the family itself was somewhat dysfunctional, that it wasn't like your average everyday lawyer's family, not that there ever is a average everyday lawyer's family. And I think to a certain extent that was probably a good thing to do because there clearly were fractured family dynamics there. What to me is interesting is that there was never really any concrete discussion of how he was killed. And I thought the opening statement by the prosecution was not particularly well done in that respect. But the key thing I had trouble figuring out in that opening statement is, what is the house tour all about? Why are we looking at the real estate? Why are we looking at these house beautiful pictures? Was there a chase through any of this? Is there something that tells us how bad the situation was because they were in all of these rooms, or is this just an opportunity to familiarize the jury with how much money they had? Because that's sort of what it looked like. I think what I would have done if I had been the prosecutor in this case is I would have kept it simple. I would have started with that timeline that he did. I would have taken it from there. I would have taken out and I would have shown photographs of the burn pile. And I would have said, this is where she shot him. This is where she put him in the burn pile. And, he was a big man and they only got 30 pounds worth of stuff when they recovered the body. This is what you need to know. And there are all these other factors that point toward her guilt. I would have done it in a much more methodical way, and I think I would have done it in a much shorter time frame. Because as long as you get all of the elements of the crime in terms of the evidence, because you can put in evidence that you don't talk about in opening statement, but if you don't cover all of the elements, if you don't say we're going to have evidence on this and this and this and this, well, in that situation, you're probably going to lose on a directed verdict because you haven't said that you have that evidence. But if you can always add additional evidence as long as you cover all of the elements of the crime. I just feel like if I was the county prosecutor here, I would wonder why that opening had to take so long. Why, when the guy was killed out by the burn pile, why it was necessary to wander through the house. I'm not certain that they did themselves any favors by getting that information in and getting all of the other information in about how weird the family was if they were not going to tie it back to the actual act. And that, I think, is the chief limiting factor in this opening statement. You're free to disagree with me, and if you think I've missed something, please tell me. But overall, this is how the opening statement ended.
Y'all forget about all this out here. My job, representing the district attorney, is to present this case to you without fear, favor, or affection. Your job, under your oath, is to speak the truth. I talked to you about veritas. You see the word verdict. It's truth, speak. It's the word veritas with dit in Latin, to speak. When you're done with this case, take all the time you need. Forgive me when I bumble through things, when I get sideways, when I'm doing my job. But remember, I am representing a voice that has been snuffed out and taken away. And Megan Frankis and I are going to present you with the evidence. And there's two sides to the truth. That is, where you see the deceit and the lies in this case, that points to who did it. When you see the opportunity, the means, and the motive, money, sex, new life, the truth, as sad as it is, as hard as it is that the defendant murdered and desecrated her own husband.
Well, Like I said, I didn't think it was a particularly good opening statement. You have to tell me what you think. Give me your best shot. Explain to me what you think the prosecutor did well. Explain what you think he did wrong. Send me an email or drop the comments down below. Whatever you do, I'd just really be interested in your thoughts on this case. Thanks again for watching. And as always, if you have an opportunity today, do something kind for someone, and then come on back down here, join me at the beach, and we'll talk about something else that'll be as interesting as this one. Hey, as I said at the beginning, none of what I said is legal advice, but let me tell you what, the stuff that's going to be right up here, these are the things that YouTube thinks you might be interested in going forward. Have a terrific day.